SEC and Ripple XRP will make an important statement about court on the 16th of January. U.S. Representative Brad Sherman recently advised the Securities and Exchange Commission, SEC, to go after crypto exchanges that supported Ripple's XRP token. However, in a recent interaction with Fox Business journalist Eleanor Tourette, Sherman made another claim against the token. Welcome to the Finance Up channel. If you liked this video, don't forget to like it and subscribe to the channel. Do you think the analysts are right about XRP? Write the answers in the comments. Giving away 500 XRP at the end of the week. One random subscriber will receive XRP coins. Take a look at the instructions in the comments section. All you need to do is write the word XRP, watch the video to the end, to like and subscribe. According to James K. Phelan, Judge Torres can make one big written decision on unresolved issues of the trial, including petitions for summary trial based on precedents. Ripple General Counsel Stuart Alderoty, who shared the news about the historic milestone reached in the lawsuit, believes that Ripple has fought well over the past 2 years. In December 2020, the SEC filed a lawsuit against Ripple and 2 of its executives, alleging that the $1.3 billion sale of XRP was an unregistered securities offering. Alderoty mentioned that the summaries of the responses would mark Ripple's final submission in his bid for the court to rule in her favor. He says that Ripple is proud of the protection it has put up on behalf of the entire crypto industry, noting that the company has always played fair with the court. In a 62-page court document, the SEC argues that it is entitled to a summary judgment because the defendants did not object to the substantial fact that the XRP sales constitute an offer of an investment contract under Section 2(1) of the Securities Act of 1993. In addition, the SEC provided 3 facts proving that the Ripple XRP offer is an investment contract. According to the agency, Ripple and its executives did not dispute that the blockchain company received $2 billion from investors in exchange for XRP. In addition, the defendants also did not dispute the fact of establishing general entrepreneurship in the Howey test. The agency noted that the defendants' efforts linked the fortunes of XRP investors to each other, citing an excerpt from a memo by lawyer John Deaton Amici Curiae, which states that Ripple's loss will harm investors. In addition, the SEC argued that Ripple did not dispute another important aspect of Howey's test, the expectation of profit from the efforts of others. The defendants made an avalanche of public statements indicating that they would take steps to increase the value of XRP. Partly because of Ripple's giant pile of XRP, potential and actual investors realized that Ripple was financially forced to do just that, the agency said. According to the SEC, Ripple's opposite argument is that many XRP investors did not consider buying a crypto asset as an investment in a blockchain company. The U.S. Securities and Exchange Commission said that this argument does not comply with the law, since the main question should be whether Ripple has forced potential investors to expect profits from the efforts of others. Will we finally see the documents for William Hinman's speech in 2018, for which the SEC has been fighting for a long time so that they would not end up with Ripple and become public? The documents were transferred to Ripple, but remain classified to the public. Lawyer Phelan believes that the judge will declassify any document, including Hinman's documents, only depending on whether she relied on him when making her decisions. Hinman declared Bitcoin and Ethereum not securities. Although he did not talk about XRP during the speech, Ripple believes that the agency discussed XRP during the preparation of the speech. Notably, the SEC and Ripple have officially filed sealed briefs with responses to the brief judgment, and many expect the parties to refer to Hinman's documents in their responses, but that may not be the case. James K. Phelan shared his opinion on the disclosure of Hinman's documents and the opportunity to see how the parties refer to excerpts from the documents in their respective response summaries. I have some thoughts about deadlines regarding Hinman's documents, motions for summary judgment and unresolved issues of secrecy. Instead of typing a long topic, I wrote them in an attached document. 3 big issues remain unresolved. Petitions for a simplified decision. Expert challenges, Daubert petitions. Problems with the classification of expert reports, Hinman documents and other materials referred to by the SEC and Ripple. Phelan said he doesn't think the summary judgment response summaries will refer to excerpts from Hinman's documents. According to the lawyer acting for Ripple, if the defendants refer to the drafts of Hinman's speech in 2018, the SEC will edit such links with reference to parts of Hinman's documents. I don't think we'll see references to Hinman's papers in the following responses. To the extent that Hinman's documents are mentioned, I think the SEC will edit these links as they have done in the past, he said. In addition, Phelan also commented on the classification of other undisclosed documents, including expert opinions and materials referred to by the parties in their petitions. The lawyer said that he also does not think that U.S. District Judge Annalisa Torres will rule on all outstanding issues of classification soon after the parties file an objection to the joint requests for classification on January 9, 2023. The presiding judge in Ripple v. SEC lawsuit will not approach the rest of the case using this approach. After filing motions for summary trial, objections, and responses, the XRP community looks forward to U.S. Judge Annalisa Torres' ruling on the lawsuit to determine whether the crypto asset is a security. Although the XRP community hopes that Judge Torres will rule in Ripple's favor, some stakeholders believe that Ripple will lose the case. Gene Hoffman, Chief Operating Officer of Chia Network, is one of the cryptocurrency stakeholders who expect Ripple to lose the case against the Securities and Exchange Commission. In a recent tweet, Hoffman notified XRP holders that former SEC Corporate Finance Director William Hinman had informed Ripple executives that XRP was a security. He shared a screenshot of the SEC's claim in a recently filed response to a brief court ruling, urging XRP holders to prepare for the future after the loss of Ripple. Did you know that Bill Hinman told the management of Ripple that, in his opinion, XRP is a security in 2019? I don't either. Prepare for a future Ripple SEC loss. The founder of Crypto Law and the lawyer acting for Ripple, John Deaton, responded to Hoffman's statement, saying that he would put the comment in the proper context using facts. Deaton said that 2 months after Hinman's controversial speech in June 2018, when the former SEC executive declared ETH and BTC not securities, Ripple CEO Brad Garlinghouse and CTO David Schwartz met with former SEC Chairman Jay Clayton and Hinman to also get clear rules for XRP. He added that on June 13, 2018, the day before Hinman's controversial speech, SEC lawyers conducted a detailed analysis of XRP, applying the Howey test to determine whether the crypto asset is a security. According to Deaton's lawyer, if the SEC had been sure that XRP was a security, Clayton and Hinman would have informed Ripple executives at that meeting. However, Deaton claims that the agency never informed Garlinghouse and Schwartz that SEC enforcement lawyers considered XRP a security. This meeting between Clayton and Hinman with Garlinghouse and Schwartz was the perfect opportunity to tell Ripple that XRP is a security, assuming the SEC lawyers came to that conclusion. Deaton said that if the SEC had concluded that XRP was a security, the agency's enforcement division would have recommended filing a letter of enforcement action against Ripple. He added that the SEC would not sit idly by for more than a year after concluding that XRP is a security and watching Ripple executives sell illegal securities to the public. Deaton also says the SEC would have turned over the XRP memo at the time of discovery to give securities regulators an edge in the lawsuit. If the 2018 XRP memorandum had concluded that XRP was clearly a security, the SEC would have issued it for discovery, as was done in the minutes of the August 2018 meeting. If the conclusion on XRP designated it a security, the SEC would have handed it over and stated that Ripple has enough time to fix it. In addition, Deaton's lawyer said that in January 2019, Coinbase and its security lawyers met with Hinman about the exchange's intention to list XRP. Coinbase lawyers informed Hinman and the SEC that they ran XRP through the Coinbase framework to determine whether an asset meets the definition of a security. It is noteworthy that the SEC did not object to Coinbase, and on February 25, 2019, the exchange listed and promoted the widespread adoption of XRP. The current price of XRP for today you can see yourself on the screens, and the trading volume for 24 hours is $1,294,436,065. We are updating our XRP price in US dollars in real time. XRP has dropped 4.08% in the last 24 hours. Do you think XRP will be able to win the court and restore its former price? Write the answers in the comments. That's it for today. Thank you for watching this video to the end. If you liked it, then don't forget to like it and subscribe to the channel.